Hi everybody, Professor Christina here, and today we're going to be talking about ethical leadership and AI. We're going to explore some data ethics frameworks, privacy laws, and platform rules. Ethical AI marketing doesn't require inventing your ethics from scratch. AI ethics falls into three categories. Data ethics, which govern the way AI systems use consumer data to target customers, representation and accuracy, and bias and stereotyping. Companies often use AI in the context of their data analytics and consumer targeting. As a result, the first step in ethical use of AI draws on ethical guidelines we already have, the frameworks and regulations around using consumer data. As AI allows us to use data about customers more precisely than ever before with less human oversight, it's critical that we look at those frameworks anew from an AI perspective. There's a mature body of thinking about data ethics, a substantial framework of laws governing how you can collect data and reach customers, and a layer of platform rules that often restrict marketers more than the law does. Today we'll cover all three. A practical data ethics framework you can apply to any AI initiative, the major privacy and marketing laws every AI leader needs to know, and the advertising platform policies that govern what you can and cannot do in practice. Let's start with the framework. In his book, Ethics of Big Data, technology consultant Cord Davis argues that every organization working with data at scale needs to grapple with four elements: identity, privacy, ownership, and reputation. Identity asks, what is the relationship between a person and the data that represents them? When your AI builds a profile of a customer, that profile becomes a kind of digital identity, one the customer may never see and one that shapes how your systems treat them. Is that data identity a fair representation of the person? Privacy asks who should control access to data about an individual. Not just who legally can access it, who should. Customers share data in one context, like completing a purchase, and AI makes it trivially easy to use that data in entirely different contexts. Davis pushes us to ask whether those secondary uses match what the person reasonably expected. Ownership asks who owns data about a person and what obligations come with holding it. If a customer's behavior generated the data, do they retain any rights over it? Can those rights be transferred when data is sold or shared? Your answer shapes everything from your consent language to your data partnerships. Reputation asks, how does data determine how people are judged? AI scoring systems like creditworthiness, purchase propensity, and churn risk are reputation engines. Davis's question is whether the people being judged have any ability to know about, correct, or contest those judgments. What makes Davis's framework practical is his emphasis on values alignment. Your organization already has stated values, and the real work of data ethics is honestly examining whether your data practices match them. He recommends building a shared vocabulary and explicit ethical discussion into normal business decision-making, so these four questions get asked before any initiative launches, not after a scandal. Now, the law. Think of privacy law as accumulating in layers, and note that older laws still apply. HIPAA from 1996 protects health information held by covered entities like providers and insurers and their business associates. If you market in or near the healthcare industry, using protected health information for marketing generally requires explicit patient authorization. And even outside HIPAA's scope, regulators increasingly treat health data as demanding special care. COPPA, the Children's Online Privacy Protection Act from 1998, requires verifiable parental consent before collecting personal information online from children under 13. The FTC enforces it aggressively. Google and YouTube paid $170 million in 2019 over alleged COPPA violations. If your AI personalizes experiences on services directed to children, this law applies to you. CAN-SPAM from 2003 governs commercial email. No deceptive headers or subject lines. Identify the message as an advertisement. Include a physical postal address and honor opt-outs promptly. Notice what it doesn't require is prior consent. That makes U.S. email law far more permissive than most of the world, which is why international campaigns can't run on U.S. assumptions. The TCPA from 1991 is stricter for phone. Marketing robocalls and texts generally require prior express written consent. GDPR, effective in 2018, changed the global baseline. It requires a lawful basis for processing personal data, sets a high bar for valid consent, grants individuals rights to access, correct, delete, and port their data, and backs it all with fines up to 4% of global annual revenue. If you use AI for automated decisions with significant effects on people, GDPR gives them additional rights around that too. CCPA, California's law effective in 2020 and expanded by the CPRA, gives consumers rights to know what's collected, delete it, correct it, and opt out of the sale or sharing of their personal information, including sharing for targeted advertising. And California is no longer alone. A growing list of states have passed comprehensive privacy laws, so U.S. compliance now means navigating a patchwork. Finally, the layer many marketers underestimate: platform rules. Advertising platforms restrict far more than the law requires, and their policies are contracts you accept to use them. Google Ads, for example, restricts targeting and ads for certain categories of goods and services: healthcare and pharmaceutical ads, gambling, alcohol, financial services, and political advertising all face certification, verification, or targeting requirements. Most relevant to AI marketers, Google's personalized advertising policies bar targeting people based on sensitive categories such as health conditions, negative financial status, race, religion, or sexual orientation, even when your AI could infer those things easily. Meta imposes similar limits, including special restricted targeting rules for housing, employment, and credit ads that emerged from civil rights litigation. The pattern to internalize: just because your AI can identify an audience doesn't mean the law or the platforms will let you target them. Next up, we have issues of representation and accuracy. Using AI-generated images of products can mislead consumers, showing products that don't exist, or at least not in the form presented on screen. AI also makes altering photos easier than ever before, reviving the controversy over issues such as airbrushing images in fashion and beauty advertising. It's important to ensure that any images used in advertising, marketing, and on a website depict the actual product, business, and results consumers can expect. Misrepresenting your offerings through AI-generated or altered images risks losing consumer trust, as well as being responsible for false advertising, which carries legal consequences. Avoid using AI to generate product images, and if you do use AI, ensures that the product in the pictures looks like the real product. Avoid using AI to create images of results, for instance, of using a cosmetic. It may seem harmless to generate an image of your business, but don't use it to create an impression that your business is larger than it is or different. For example, if you're online only, don't make images of a store that does not exist. Doing so creates consumer backlash and is not honest. Finally, we have a responsibility as marketers to avoid perpetuating negative biases in society. A popular AI slide generating tool, for instance, only generated images of men when asked to create presentations including photos of professionals ranging from professors to doctors. This type of bias happens easily with AI, which has been trained on old data sets that reflect the reality of past times or current biases in society. Checking AI outputs to prevent the perpetration of harmful stereotypes is important, both to maintain consumer trust and to align your business with ethical best practices. Cord Davis recommends building a shared vocabulary and explicit ethical discussion into normal business decision-making, so the 4 questions get asked, again, before the launch of an initiative, not after a scandal. Audit your shared values. What does your organization say it stands for? Map data practices to values. Honestly examine whether identity, privacy, ownership, and reputation practices match those values. Build ethics into workflows. Make ethical review a standard step, not a post-scandal response. And check outputs continuously. Review AI-generated content for accuracy, representation, and bias before publishing. AI ethics is an emerging field. The leaders who struggle are the ones who treat compliance as the whole job. The law lags behind technology, and platform policies change faster than your strategy documents. But if your team is genuinely asking the right questions and honestly checking your data practices, representation and accuracy, and potentially biased content against your stated values, you'll be ahead of the regulations instead of scrambling to catch up with them. The key insight? Ethics gives you the questions, the law gives you the floor, and platforms give you the guardrails. AI literate leadership means operating fluently in all 3 at once.